one of the reasons I wanted to have you in particular on is that for the first topic we're going to discuss, you were dead on the money here. This is the Fourth Circuit case on the assault weapons ban in Maryland that has now, there's been some interesting legal maneuvering that you kind of predicted might happen. Can you just walk people through exactly what's going on there?
Yes, what the United States Court of Appeals for the Fourth Circuit out of Maryland and Virginia did in the Bianchi case, which addresses whether or not Maryland's quote-unquote assault weapon ban is constitutional under the Second Amendment, is, let me use a very academic word here, pathetic. It's pathetic that what you had here, just to jog everyone's memory, is that Maryland enacted a semi-automatic rifle ban in all intents and purposes. The Fourth Circuit heard a three-judge panel on the Fourth Circuit heard the argument, I believe, at the end of November, early December of 2022, right?
And that was after the Supreme Court.
It was after the Supreme Court decision in Bruin. Mm-hmm. The truth is, Bruin does not really impact assault. Bruin does not really impact the relevant law for arms ban cases. The relevant Supreme Court precedent when you're dealing with an arms ban case, whether it be a magazine ban, whether it be a AR-15 ban, is really the Heller decision. But what Bruin did is they remanded a bunch of cases that were up on cert back to the lower courts to say, just, do it again, take a look at Bruin, see what you think, and then send it back up to us because we have other work we have to get to with the rest of the Constitution, the rest of the federal statutory world. So it goes back down to the Fourth Circuit Court of Appeals. There is a three-judge panel that hears argument, again, like I said, around December 1st or so of 2022. Hear what I just said, Stephen? 2022. That three-judge panel then, I listened to the argument. It was pretty clear it was going to be 2-1 in favor of the Second Amendment. There was one judge that really hated all guns at all times, you could tell. And then the other two were pretty clear. They understood that Heller was the relevant law and we're going to apply it faithfully. And the Second Amendment was going to prevail in the Maryland assault weapon ban. And I use assault weapon as a political propaganda term, of course, but that's what the bill is called. So that's why I'm referencing it. But really, this is an AR-15 semi-automatic rifle ban in Maryland. So, of course, what happens is it looks, for all intents and purposes, that the panel is going to rule in favor of the Second Amendment plaintiffs. Now, here's the kicker. So this goes on. We're waiting for over 1 year. Hear what I just said? 1 year we're waiting for a decision from the panel on what should be a really relatively straightforward case. You apply to Heller, you write up, this is what Heller says. Bruin doesn't affect it because keep in mind that Bruin cites positively the Heller case something like 80 times. So then what happens is all of a sudden we have this massive delay. At the same time, we start to get Second Amendment decisions out of the Fourth Circuit, like the Maryland Shall Issue case that were argued after Bianchi, yet were decided before Bianchi in situations much more novel and complex dealing with the new Bruin standards. So it becomes very odd as to how is it that a simple case that just requires Heller to be applied to a ban on a weapon that's commonly owned, why has that been argued first and still not decided when all these other Second Amendment cases are being decided by the Fourth Circuit? Some of those cases, mind you, had judges that were on that panel that heard the Bianchi case. So there was pretty clear some sort of games were taking place in the Fourth Circuit, which is notorious for being a hyper-partisan, liberal, activist court against all conservative issues, including but not limited to the Second Amendment. So that got me thinking. And what I predicted at the 1 year mark is I said, there's a game being played here. And this is a court that has played games before on what I would say politically charged topics. Specifically, several years ago, there was a voting rights case that was argued in front of a panel, and it looked very favorable for, I guess, really kind of the conservative viewpoint, if you will. And lo and behold, what the Fourth Circuit did internally, and this is going to make your eyes glaze over a little bit, but it's important to understand this, that what the Fourth Circuit did internally was rather than let the panel decision come out and then have a request for en banc review, which means that all the judges will hear the case, not just the three-judge panel. What the Fourth Circuit did in that case of Weiss, involving the Voting Rights Act is the entire court decide to take the case away from the panel because they don't want a favorable conservative decision. They took that case away from the panel and they en banced it without anybody even knowing they did it. And then they issued an en banc ruling in favor of really the Democratic Party, if you will. And the dissent said, this is absurd. The way this works is the panel, three-judge panel, issues a ruling, then there's a request for en banc, and then they decide whether or not the court should hear it en banc. You never take it away from the panel. So that is my prediction. I predicted that game they played in the voting rights context was exactly what I thought they were going to be doing in the Second Amendment context with this Bianchi case, because it looked like we were going to get a very powerful decision in favor of the Second Amendment in Bianchi. And lo and behold, just a few weeks ago, we find out that indeed, and unfortunately for Second Amendment rights and Maryland gun owners, that the Fourth Circuit has decided after a year of waiting to internally en banc this case. And now they've scheduled this case en banc to be heard again with oral arguments at the end of March. There is no excuse for this behavior. Let me be clear. There is no excuse for this behavior for any judge, because if the Fourth Circuit knew they wanted to en banc this case because they thought it was so important or whatever the reason is, there was no reason whatsoever that they needed to wait over 1 year before they decide then to en banc the case. This is purely, and in my opinion, this is clearly about delaying the inevitable, which is the U.S. Supreme Court, when they get to an AR-15 ban case, is going to knock them out of the park as being clearly unconstitutional under Heller. So the only chance, as I see it, that the anti-gunners and the anti-gun judges in this country have to allow for these bans to continue in these terrible anti-gun blue states is to prevent a case like this from getting to the Supreme Court. So they are doing everything they can to delay to prevent this court from hearing it, all in the hope, and this will sound gruesome, but it's true, all in the hope that one of the conservative justices, such as Justice Clarence Thomas or Justice Samuel Alito, one of them leaves the court so they can replace him with another Brown Jackson. That is the entire strategy of the anti-gun movement in this country when it comes to arms ban cases such as magazines and AR-15 bans.
Okay, so you're saying that this maneuver, this is not a common thing to happen. I've never seen this happen.
Extraordinarily rare. Extraordinarily rare. This only occurs. Usually you will only see something like this, and even then you won't see it, if you're dealing with like a presidential election and you're like 1 month before an election and they have to get a result immediately and there's no time for appeals because you have to set the rules before an election or something extreme like that. It basically, for all intents and purposes, it never happens. You don't need to learn about it in law school because it literally never occurs. And yet coincidentally it occurs. And why did the Fourth Circuit wait over a year to do this? If they wanted to en banc this case internally, they could have done it, a year earlier, but they didn't. Why? Because we know why. They want to slow walk these cases to make sure this Supreme Court never gets an AR-15 ban in front of it.